Here's a tech industry battle that's getting messier by the day. A major medical device company just declared war on the U.S. government itself over Apple's sneaky workaround to bring back a banned feature. Masimo Corporation, the medical technology powerhouse behind advanced patient monitoring systems, has launched a federal lawsuit against U.S. Customs and Border Protection. Their beef? The government agency allegedly helped Apple circumvent a trade ban that was supposed to protect Masimo's patented innovations. But here's where it gets controversial. Apple might have found a legal loophole that could change how tech companies handle patent disputes forever. To understand why this matters, let's rewind to the drama that started it all. Back in October 2023, something unprecedented happened in the tech world. The International Trade Commission, think of them as the referees of international trade disputes, dropped a bombshell ruling. They determined that Apple's beloved blood oxygen monitoring feature, available on the Apple Watch Series 9 and Ultra 2 models, was essentially stolen technology that violated Masimo's carefully protected patents. The technology in question revolves around pulse oximetry, a sophisticated method of measuring blood oxygen levels using light-based sensors. For those unfamiliar with the science, imagine tiny light beams penetrating your skin to analyze how much oxygen your blood cells are carrying. It's the same technology you see in hospitals when nurses clip that little device to your finger. Masimo has spent years and millions of dollars perfecting this technology, and they weren't about to let Apple profit from their innovations without a fight. The immediate aftermath was swift and brutal for Apple. The tech giant faced a complete sales ban on two of their most popular smartwatch models right in the middle of the crucial holiday shopping season. For a company that generates billions from wearable technology, this wasn't just an inconvenience. It was a potential financial disaster. Apple's solution? They performed what many considered corporate surgery, removing the blood oxygen feature entirely through a software update just to get their watches back on store shelves. But Apple wasn't about to give up that easily. And this is the part most people miss. The company's engineering teams were likely working around the clock to find a workaround that wouldn't violate the existing patents. Fast forward to just last week, and Apple pulled off what some are calling either a stroke of genius or a controversial end run around the legal system. The blood oxygen monitoring feature mysteriously reappeared on Apple Watch Series 9, Series 10, and Ultra 2 devices. However, there's a crucial twist that changes everything. Instead of the watch itself performing the blood oxygen analysis, the data processing now happens on a paired iPhone. This technical sleight of hand might seem like a minor detail, but in the world of patent law, it could be the difference between legal compliance and infringement. By shifting the computational work from the watch to the phone, Apple argues they're no longer using Masimo's patented technology in the way that violated the original ruling. Apple confidently announced this development with a statement that would later ignite Masimo's fury. This update was enabled by a recent U.S. Customs ruling. Those 9 words have now triggered a legal battle that could reshape how government agencies handle patent disputes in the technology sector. Here's where the controversy deepens and things get really interesting. Masimo claims they discovered this development not through official channels or legal notifications, but only after Apple made a public announcement on August 14th. According to their lawsuit filing, U.S. Customs and Border Protection issued what's called an ex parte ruling on August 1st, essentially a one-sided decision made without consulting all affected parties. In legal terms, an ex parte ruling means the decision was made with input from only one side of the dispute. Imagine a referee making a game-changing call after hearing arguments from only one team, while the other team sits silently on the bench, unaware that a crucial decision is being made. That's exactly what Masimo alleges happened here. The medical technology company isn't mincing words about their outrage. Their lawsuit, filed in the U.S. District Court for the District of Columbia, accuses Customs and Border Protection of overstepping their legal boundaries, acting unlawfully, and violating Masimo's fundamental due process rights. These are serious legal allegations that strike at the heart of how government agencies should operate in patent disputes. Masimo's legal team is demanding that the court immediately block the August 1st customs ruling, which would effectively shut down Apple's blood oxygen monitoring feature once again. But their arguments go beyond just this specific case. They're claiming that allowing this ruling to stand sets a dangerous precedent for how patent protections work in international trade. Each passing day that this unlawful ruling remains in effect irreparably deprives Masimo of its right to be free from unfair trade practices and to preserve its competitive standing in the U.S. marketplace, the company stated in their legal filing. This language reveals the high stakes involved. Masimo isn't just fighting over one feature on one device. They're battling to protect their entire business model and market position. But here's the million-dollar question that's dividing tech industry observers. Is Apple's iPhone-based workaround truly different enough to avoid patent infringement? Or is this just clever technical maneuvering that achieves the same end result through different means? Some patent attorneys argue that Apple's approach represents legitimate innovation, finding a new technical path to achieve similar functionality without directly copying Masimo's protected methods. Others contend that this is exactly the kind of end run around patent protections that undermines the entire system designed to reward and protect innovation. The implications extend far beyond just these two companies. If Apple's workaround is allowed to stand, it could signal to other tech giants that patent disputes can be resolved through creative engineering rather than licensing negotiations or court settlements. On the flip side, if Masimo wins their challenge, it could establish stricter boundaries around how companies can modify their products to avoid patent infringement claims. What makes this case even more intriguing is the role of government agencies in private patent disputes. Traditionally, Customs and Border Protection focuses on enforcing trade rules and preventing prohibited goods from entering the country. But this case pushes them into the complex world of patent law interpretation, territory that some legal experts argue they're not equipped to navigate alone. The timing couldn't be more critical for both companies. Apple is heading into another crucial product launch season, where wearable technology sales typically surge. Meanwhile, Masimo is fighting to maintain their competitive edge in a medical technology market that's increasingly attracting tech giants like Apple, Google, and Samsung. For consumers caught in the middle, this legal battle raises important questions about the future of health monitoring in consumer devices. Will patent disputes slow down the integration of advanced medical features into everyday technology? Or will they push companies to develop even more innovative solutions that benefit everyone? As this legal drama unfolds, one thing is certain. The outcome will likely influence how tech companies approach patent challenges for years to come. Whether you view Apple as an innovative problem solver or a patent-dodging rule bender might depend on your perspective on intellectual property rights in the digital age. What do you think? Is Apple's workaround a legitimate technical solution, or are they just gaming the system to avoid paying licensing fees? Should government agencies have the power to make patent-related decisions without consulting all affected parties? The comments section is the perfect place to weigh in on this controversy that's shaking up both the tech and medical device industries.